It's great to be joined today by James Whitman, who's the Ford Foundation Professor of Comparative and Foreign Law at Yale Law School, also author of this book, Hitler's American Model. It's so great to have you on. Let's start with the book. Many people have some understanding of what we sort of know colloquially as Nazi race law, but they may not know all of the different components that were either inspirations or otherwise sources for that race law. So let's start at the very beginning. Nazi race law refers to what in the context of World War II?
Well, it's important to distinguish between the early years of the Nazi regime and what came later. What we remember most these days is, of course, inevitably the Holocaust. But in the early 1930s, after Hitler first seized power, the Holocaust was really not yet on the horizon. There was no notion among the Nazis that they would engage in mass killing, which seemed, if nothing else, impractical. The early version of Nazism that's embodied in the notorious Nuremberg laws of 1935 involved a different program whose aim was to force the Jews to flee from Germany. What it involved in particular was two measures. First, the creation of a new form of second-class citizenship for Jews, and second, the introduction of measures intended to forbid interracial marriage between Jews and what the Nazis called Aryans, that is their concept of Germans, and also extramarital sex.
And talk to us a little bit about some of the specifics of how those laws were written, some of the details maybe that people have not heard of sort of the logistics of this.
Well, the laws, in a sense, were written very hurriedly in reaction to a diplomatic contretemps with the United States in September of 1935. But they'd been in preparation for quite a long time, and in particular, the preparation had involved a great deal of careful study of American models. That's for a very straightforward reason, really. The United States was the leader in innovative racist lawmaking in the early 1930s, something that Europeans, particularly Europeans on the right wing, have been very conscious of for quite a long time. The Nazis knew it too. Hitler himself, in Mein Kampf, referred to the United States as the one state that had made progress toward the creation of a healthy racist order.
So let's dig into that, because for most people who learned, U.S. history of World War II in school, the sort of general understanding is, hey, the United States, when we got into World War II, we were against Hitler, we were against the Nazis. There would be no such connection or inspiration in terms of anything that Nazis did at any point from the United States. So talk to us about what specifically may have been an inspiration in terms of the Nuremberg laws that was going on in the United States.
Well, it's quite true that when the United States entered World War II, it was on terms of great hostility with Nazi Germany. There's no doubt about that. But the hostility really didn't clearly introduce itself into relations between the two countries until the late 1930s, really not until 1937 or so. In the early 1930s, the Nazis still saw a great deal to admire in the United States. Among other things, they admired Franklin Roosevelt and his style of government, shocking as it is to hear it now. But beyond that, the Nazis saw a great deal in the American race order to admire. This was, of course, the era of Jim Crow. Jim Crow legislation, as everybody knows, targeted African Americans in the South. But there was more to it than that. There was a great deal of national and nationwide race-based legislation in the United States, too. The United States was in particular famous for its immigration legislation, which was designed to guarantee the continuing dominance of the white Anglo-Saxon Protestants, who were thought of as the true and natural inhabitants of the United States. The United States also had created something of great interest to the Nazis, forms of second-class citizenship, not even so much for African Americans, because their citizenship was, at least in theory, guaranteed by the 14th Amendment, but for members of other races, such as Filipinos, Puerto Ricans, and to some extent Native Americans. This is something American lawyers had done in a spirit of great creativity that the Nazis often found admirable.
How do we know? I mean, you talk about this in the book, but how do we know that that Nazis were looking to what was happening in the United States? What historical record do we have?
Well, they said so themselves. The most dramatic evidence comes from a stenographic transcript of a meeting held in the summer of 1934 to plan the Nuremberg laws. That meeting in particular turned on the question of how to introduce what in the United States is called anti-miscegenation legislation. That is law banning interracial marriage. And the participants in that meeting engaged in very close examination of state statutes from all over the United States. In fact, at the beginning of the meeting, the Minister of Justice presented a memorandum on American law, which had been put together by the Justice Ministry precisely for the purposes of this discussion. Beyond that, there was a great deal of published literature describing, not always in admiring terms, but very often in admiring terms, American law. Among the published literature, maybe the most dramatic example comes from a thick volume called the National Socialist Handbook for Law and Legislation from 1934 and 1935 that described the United States as the country that had achieved the fundamental recognition of the need for race-based law, a fundamental recognition that it was Nazi Germany's calling to bring to full fruition.
So the big picture of this, I'm sure, will come sort of as a shock or surprise to many in our audience who were not aware of this, as I mostly wasn't before I read your book. Generally speaking, was there any kind of effort to suppress knowledge about the inspiration that the Nuremberg laws drew from what was going on in the United States, or has it been because of lack of interest that it's not been discussed nearly as much as we might imagine? Or why do you think that this understanding is missing for many people?
I don't know that there's been any deliberate suppression in the United States. And it's not exactly that there has been in Germany either. But the topic is one that it's very difficult for Germans to discuss. In order to do this work, one has to be willing to plow through an awful lot of technical German law. And for the most part, naturally, it's Germans who would do that. But in Germany these days, it's very, very difficult for serious scholars to make a career if they're willing to say anything that would suggest in any way diminishing the moral responsibility of Germany for the crimes of the Nazis. And in that sense, it's entirely understandable that Germans have not investigated these issues. I suppose you kind of have to be an American in order to be willing to do it.
Let's take a pause right there. We've been speaking with James Whitman, who's the Ford Foundation Professor of Comparative and Foreign Law at Yale Law School. This is his book, Hitler's American Model. We are going to pick it up with him there on tomorrow's program.